So look, welcome everyone to this final sprint to the end, and I think we've got a bit of a gem to finish off with, and you'll see that there's been some very neat circling back to some issues that we started the day with. I'm very quickly going to introduce the three speakers so I don't take any of their time. The first, we're delighted to have Associate Professor Mary Synge with us, who is joining us from the University of Exeter, at least until the end of, I think, this month, Mary. But the reason for Mary's joining us on this session is that she's not only published very widely in the charity space, and I'll share the CVs with you perhaps on the chat later, but what's really important is she's just about finished a very important monograph on the topic of the university charity. So she's very well qualified to speak on this topic and start us off. And I'll introduce our two next speakers after that, but I think we might head off with you first, Mary. Thanks.
Thank you, Anne. I'm just going to try and share my screen. I hope it works. Does that work?
That's fine, thanks.
Are you seeing it?
Yep, we can see it.
Good. Well, thank you, everybody. Yep, it's Olympic season, so this will be a bit of a sprint. Anne's right. I've been asked to share the questions which I believe arise when we look at universities through a charity law lens. I'd like to say I haven't quite finished the monograph. I'm on the last chapter, so it's very much a work in progress, which is why I welcome any thoughts. So I don't have long to do that, and my screen isn't working. There we are. Okay, so the overarching research questions are actually very straightforward. Number one, are universities charities? And number two, if so, what are the consequences of that charitable status, in particular, in terms of the way universities operate and in terms of their relations with the state? The first question, are universities charities? Well, that may seem a bit of an odd question, particularly if you're in a jurisdiction where the universities are registered. It's not a question I'd have asked here 50 years ago, I'm quite sure. However, the use of the title university has expanded significantly to cover an increasing range of institutions. I don't believe that universities are commonly perceived to be charities, either by the public or in the literature. And our legislation calls universities exempt charities insofar as they are charities, which of course begs the question. Unfortunately, the question hasn't turned out to be quite as straightforward as I had anticipated or certainly hoped. Whether something is a charity or not is for us a matter of law. It's not a question of attaching a label to something, I don't think. And here, yes, the biggest question is, where is that dividing line between charity and government? And we have a specific, rather circular looking provision in our legislation. And this was an addition at 2 o'clock this morning. We have got the Office of Profit question as well. And there are some technical questions which arise in relation to this question. Things like, how important is the founder's intention? And do we need that level of altruism or benefaction or bounty? And in particular with our very recent universities, there are questions, I think, over whether the objects and powers that are expressed are actually exclusively charitable according to normal charity law conventions. And in our jurisdiction, there's an added problem with our former polytechnics. Now, these were institutions which were designated by the minister in the 1960s as polytechnics, in deliberate contrast to the autonomous and snobbish universities. So the narrative went. And I think some of those institutions were originally charitable, so there's a question mark over whether the designation of them as public sector institutions was effective. And more importantly, perhaps, whether when 20 years later or so, those polytechnics by statute were given autonomy, called universities and called charities, was that sufficient to create them as charities? Unavoidably, I think the conclusion is that some sort of case-by-case analysis may be needed, if not in respect of individual institution, then certainly in certain types of institution. But anyway, there's enough to be getting on with. Certainly a good number are charities, if not all. So I didn't have to abandon the project at that point, which was good news. What are the consequences of that status for the way universities operate? Well, if they're charities, then they're subject to charity law, which for me is not just what's in the Charities Act. We rely on the equitable jurisdiction. And what I'm trying to do here is look at universities through a charity law lens. And I'm asking, does charity law have anything to say to the current literature, which is generally very, very critical of universities? So for example, for those in universities who are designing and implementing education and research strategies, my question is the constitutional purpose properly construed and the overriding duty to act in the best interest of the charity, are those two things at the heart of all decision making? Or are there other things at the heart of decision making? For example, enhancing power and prestige, improving league table positions, chasing metrics and so on. And if that is the case, does that in any way undermine the purpose or neglect the duty? Those are very difficult questions, but I believe they're worth asking. Does charity law have anything at all to say about executive pay? Does charity law help to frame when remuneration might be seen as excessive? Does it say anything about bonuses? And if so, how bonuses might be calculated, if they're lawful at all? We have reports here of 95% of vice chancellors sitting on or attending remuneration committees. Does charity law have anything to say about that? Does charity law provide mechanisms for consent, particularly by the Charity Commission? And if so, are those mechanisms being operated at all? Very difficult problems arise over remuneration, over transparency, limited disclosures, contractual arrangements, and confidentiality agreements. Does charity law have anything to say to criticisms of top-down managerialism, which seems to be rife in universities? And by business model there, I really mean the modern model, certainly here, with increased lay membership on the governing body, a very powerful executive, and a very, very diminished academic voice. Does that model promote or facilitate compliance with charity law? And questions arise over where is the power and where is the liability? Are those two matched or seem to be matched in law? And the next question arises, of course, if there are any of those charity law questions arising, how do we hold the university charity to account, ignoring for the moment state regulation? So for chartered universities where there's a visitor's jurisdiction, would that be appropriate for these sorts of charity law proceedings? Does judicial review lie? Charity proceedings almost certainly lie, but how likely is it that a member of the public or an academic or student, how likely is it that they will bring those proceedings? And is this something where we might look to the Attorney General? Consequences of charitable status in terms of universities' relations with the state. Well, here, of course, I'm getting at the hallmark of independence, which we know to pertain to charitable status as well as trustees' duties. Let's assume we start off with the university charity. We've decided it's on that side of the dividing line. And then we consider some higher education policy interventions. And it's worth asking, do those threaten the hallmark of independence? I'm thinking particularly in terms of the way government sets fees, sometimes in connection with admissions, and there are other conditions around admissions. Many things are attached as conditions of funding or conditions of registration. And increasingly, universities are included in what we might see as public sector legislation for public sector bodies or public bodies and public authorities, which changes the narrative perhaps. And if the independence is eroded, is it ever eroded to such a point that charitable status is no longer applicable? And if so, what happens then? Is the university then drop into the public sector? Or might we ask whether what we are seeing is changed behaviours on the parts of universities in response to policy interventions, and those that might signal a breach of duty as opposed to a change of status? Of course, the other main point of the relationship between state and charities, the university charities, is state regulation. So it's then interesting to ask, how independent is our charity commission, our charity regulator? How effective is it? How well resourced or sufficiently resourced is it? How able and willing is it to tackle, guide, challenge universities at all, or indeed the whole sector, charity sector, in respect of executive pay, for example? And we have a particular problem here where our regulatory framework has registered and exempt registered and exempt charities And universities actually fall into both camps, which creates a two-tier framework. And the Office for Students is the principal regulator for charity law purposes over exempt universities. How effective is it in that role, and how defensible is it to give it that role? Just a couple of other consequences, if I may. The interpretation of public benefit, which requires the provision of opportunities to the poor, impacting on duties and status, and I'm thinking here of the Independent Schools Council case and our Charity Commission guidance. Does that not apply to universities? Many of you will know I'm not a great fan of this interpretation as a matter of English law at all, but let's just say I'm wrong in everything I've ever written or said about that, and it's law. Why is it not being applied to universities? Are the answers to do with law or to do with policy? And finally, and really importantly, I think, the question, can a university charity ever be sold? Can it be converted to a for-profit? Now, I believe here that there are many, many questions of charity law that arise, and I wonder whether they are to the fore and being fully heeded, for example, in respect of a couple of institutions which have recently been sold to private equity. So Regent's University, for example, was a company limited by guarantee, charitable company. Its assets and business were sold to a subsidiary of a private equity company, for-profit company. Senior management went with them to the for-profit. Very difficult to know exactly the terms of that transaction or what sums were received or will be received. And the objects were altered to become a grant-making body with a strategy still to be worked out. That's very brief. This happened last year in a very short space of time, partly in relation to COVID and a fear of insolvency. Now, I believe there are many, many questions arising there over the role of the executive. Should we be concerned about any conflicts of interest, for example, the strength of the governing body, the role of the professional advisors, and even the content of their advice in some respects. The Charity Commission gave consent to all of this. So questions over on what basis it did that, what information it had, what investigations it made, and so on. And also the role of government, which is very keen indeed in our jurisdiction to introduce alternative providers and private equity. Please do contact me if we don't have time for questions today at any time. I'd be really grateful for that.
That's
Many
fabulous,
thanks.
Mary. Look, thanks so much. Boy, what a sprint. You have been watching the Olympics, haven't you? Before I move on to our next two, because I think there's a bit of a jump in approach and themes before I introduce Natalie Silver and Katrina Williams. Mary, the question that seems to come from what you've said is that there seems to have been a massive shift. Oh, sorry, let me put this in terms of a question, whether the government funding changes have been the game changer. The governments have ceased financially supporting or becoming, university becoming dependent on government funding, and the shifts in those sort of models made the universities become more, if you like, focused on different business models. And one of our questioners in the chat is related to that, is the move to universities relentlessly pursuing international students to seek that sort of income. Has this been a major impetus to the sort of shifts that you've been talking about?
Thank you, Anne. Yes, definitely. And I think there's plenty to show that after the period of the polytechnics, which were decidedly public sector institutions, the government certainly realised, if it hadn't before, the power of the purse, the level of control that it could lever over institutions through funding mechanisms, through funding conditions. So absolutely, we've seen that. That power of the purse and almost dependence is very key. And you mentioned the business idea, and our government seems to be very keen on universities operating as businesses. And in particular, in the last 15 years, they have, having put all universities in the same melting pot, if you like, regardless of charitable status, they have actively invited universities to liberate or to deregulate their governance models, to allow them to make almost any changes to their constitutions, including over objects. The intention is that that should now be under the oversight only of the Office for Students, intent on removing the Privy Council. The Charity Commission doesn't seem to be getting a look in, unless it's a company, as Regent's was. So that sort of deregulation of governance and what we might expect over governance has led, I think, even more to the academic voice being taken out and the power of the executive. And yes, If we're chasing metrics and we're chasing income, we're definitely increasing international students. And I think it creates some perverse incentives. So there's a natural incentive to reduce grades on entry, for example, to gain a competitive advantage, to maximize income. There's a whole range of things, but
absolutely, it's interesting, isn't it? And there's massive paradoxes there, but one of the massive ones is that government, if you say government was funding, say at 100%, it wasn't hundreds of percent of cost, it's now reduced to something like 20% in Australia, I think, by the figures that I've seen. So paradoxically, as the funding, the government taxpayer funding investment in higher education has diminished, so has its impetus to universities to go out and become businesses. And it's crossed those three sector lines that we were like talking about in the Charity Law Association. But look, thank you for that. We're making a shift then, but not completely different topic to the question of funding. And I'd like to introduce you to Dr. Natalie Silver. For those of you who don't know Natalie, University of Sydney lecturer at the law school there. She's an expert on not-for-profit law and regulation. I'll send you again much more of her very deep background there. But Natalie and also Katrina Williams, who's actually not as a lecturer, but is in the Office of General Counsel. She's a senior solicitor in the university. They're going to talk, the two of them, as a double header on the charitable gifts and trusts that the university receives. So it's following this theme of funding and how these how does the university deal with the need to make these sometimes ancient gifts relevant to modern needs? But I'll let them speak for themselves. Thanks, Natalie. You're going to lead off, I think.
Thanks very much, Anne. I'm just going to share my screen. Hopefully everybody can see that. So I just first want to acknowledge the traditional owners of the land where I'm working and living, which are the Gadigal people of the Eora Nation, and pay my respects to their elders past, present and emerging. So as Anne said, we're looking at one specific issue, Katrina and I, much more of a micro presentation, I guess, than Mary's. We're looking at the issue of that's become quite relevant in the wake of COVID, which is charities' ability of charities to access retained assets. And we're looking in particular at charitable gifts, as Anne said, and historical gifts in particular, which often take the legal form of perpetual charitable trusts. And obviously they can have very significant endowments. And those endowments are invested and produce annual spending allocations. So many universities and other large charities, such as large religious and arts organisations, hold significant endowment portfolios. But as I've said on the slide here, fully utilising these assets can be challenging when the trust creates conditions that no longer reflect contemporary society or institutional practice. So when there has been changes, significant social and organisational changes since the trust was created. So this has actually become a very live issue at the University of Sydney, and I imagine at other universities as well. Katrina will speak, she'll be giving some examples of what we're dealing with now, or what she's dealing with now at the University of Sydney. But basically, we're trying to answer in this presentation two questions. Firstly, what options are available to charities seeking to vary the terms of a charitable trust? And secondly, what role, in line with the conference theme, what role does government play in assisting or impeding charities who engage in these processes? So I'm going to just quickly outline the options that are available to charities who seek to alter the terms of a trust. And I just want to say from the outset, you'll see on the slide here, we've got three main options. There are other avenues available, but these are the options that the University of Sydney is currently considering and we believe are the most relevant. So with the limited time, we're focusing in on these three. And as I said, Katrina will be actually providing specific examples at the end of each of these three options, how they operate in practice. So firstly, a CPRA application to the Attorney General or the Supreme Court. So most of you would be aware that the power to vary a charitable trust charitable trust purposes under the CPRA doctrine is very ancient. It actually dates all the way back to Roman law. And under this doctrine, donor intent is paramount. And this focus on donor intent is reflected in the common law test for CPRA, where an order will only be made if the original purpose of the charitable trust becomes impossible or impracticable to perform. So this was quite a high threshold to overcome. So there are a number of statutory reforms in each state, and I've given you an example here of New South Wales, which is the one Katrina and I are obviously focused on, Section 9 of the Charitable Trusts Act. So this section actually provides that where the original purposes, wholly or in part, have ceased to provide a suitable and effective method of using the trust property, having regard to the spirit of the trust, those purposes may be altered. So you can see here from this definition, it's a much broader definition than the common law test, and it has allowed for a broader application of the doctrine of the CPA doctrine by the Supreme Court. I've actually undertaken some research that not only looks at CPRA cases in New South Wales, but actually across Australia. And it seems that the statutory reforms, which have, as I said, really broadened the notion of what is impracticability or what constitutes impracticability on a state-by-state level, it seems that state Supreme Courts are now taking quite a permissible approach to trust variation. Such that trusts that have failed for whatever this statutory definition is in a particular state of impracticability are generally going to be allowed a CPRA scheme. Okay, so once that threshold of impracticability, statutory threshold has been passed, then the CPRA scheme is often allowed. Okay, so what that means is if you actually make it to court, your chances of success in altering the terms of the trust are actually quite high. So that's the good news. Now for the bad news. The bad news is that ending up at the court, at the Supreme Court, is the final stage of a very long, drawn-out process that is costly. It can take months, requires the charity to come up with a lot of documentation, historical records, all of that sort of thing. And these need to be provided to the Attorney General, who wields a great deal of power, certainly in New South Wales, but I believe in other states as well. Now, to make matters worse, the Attorney General in New South Wales, at least, is not particularly receptive to these applications. Yet under the Charitable Trusts Act, applications where the trust property, the value of the trust property is less than $500,000, go directly to the Attorney General. Where the trust property is valued at more than $500,000, those applications go to the Supreme Court, but they still require the consent of the Attorney General. So, so the Attorney General, the role of government here in the form of the Attorney General actually ends up serving as a sort of roadblock or an impediment for charities to be able to vary these trust purposes in order to access these charitable assets. So first, that was the first option. Second option is a judicial advice application to the Supreme Court. Now, this is only available where the charity is the trustee. It turns out with universities, often the university will be both the beneficiary and the trustee. So this is an option available to universities. And again, we have state legislation in New South Wales, it's the Trustee Act, but similar provisions in other states to Section 63, which allows a trustee to apply to the court for an opinion, advice, or direction on any question respecting the management or administration of the trust property or respecting interpretation of the trust instrument. So it's important to note, firstly, this is not an order varying the terms of the trust. It is something less than that. It's getting judicial advice to verify the trustees' interpretation of the trust terms, is valid, and that then protects the trustee in the future from a claim of breach of trust. So while this may seem more expedient than a CPRE application, it's still problematic. It's still lengthy. It's still costly, time-consuming, and at least in New South Wales, and I don't think this is the same in every other state, but in New South Wales, it still requires the consent of the Attorney General. I think in some other state, it requires the Attorney General to be advised. So we still have this role of the Attorney General here as well. So the final option is an internal, what we've called an internal CPRE mechanism. And this is available to some large charities. A number of universities have these mechanisms, or various forms of these mechanisms, through which they are able to vary the terms of a trust. So one example being the University of Sydney. The University of Sydney is a statutory corporation, and under its enabling legislation, section 25, the University Senate can apply to vary the terms of a trust if it is impossible or inexpedient to carry out or observe the terms of the trust. So we see this is actually a slightly higher bar than the under the Charitable Trusts Act. It's looking a bit more like the common law test, but it's not even the main issue. The main issue, at least for the University of Sydney, is that this is not a purely internal mechanism, because as you can see here, the University Senate has to request from the Minister for Education to effect a variation. So they have to go to the Minister, and again, it ends up with the Attorney General. So unfortunately for the University of Sydney, all roads seem to lead to the Attorney General, and as I said, that creates a particular impediment in terms of trying to vary the terms of these trusts and access these charitable assets. So I'm going to hand it over to Katrina now. Katrina is going to bring some colour to these options that I've outlined, because she's going to draw on some of the practical examples of trusts at the University of Sydney based on her own experience at the Office of the General Counsel. So Katrina, I'll hand it over to you, and I'll keep my slides up.
Great. Thanks, Natalie. And thank you to Clans for the opportunity to participate today. Firstly, if I could acknowledge the traditional custodians of the land from which I speak to you today, the Gadigal people of the Eora Nation, and elders past, present and emerging. As Natalie has said, many older universities like the University of Sydney have a rich history of donor generosity, which has enabled us to build significant endowment funds to support charitable purposes. But the vast majority of those gifts which comprise these funds are held on charitable trust and carry binding conditions as to how they can be used. And understandably, many conditions that were quite reasonably stipulated by donors up to 150 years ago, and even some of the more recently stipulated conditions, don't translate effectively to certainly this university's current environment. So we're in a position where the rate of change puts us under ever increasing pressure regarding the viability of our legacy gifts, at the same time as we're under increasing pressure to fully access the benefit of those charitable funds. As Natalie has outlined, there are certainly avenues available to the trustees of charitable gifts to vary the terms of gifts that can no longer be effectively applied due to outmoded terms. My part in today's presentation is to provide some examples from the university sector of trust terms which have made it difficult for gifts to be applied, and to highlight some of the challenges we've encountered with navigating the variation process. We've also looked at some solutions or alternative ways of dealing with the issue. There are, of course, many reasons that the terms of charitable trusts established decades and sometimes centuries earlier have ceased to provide a suitable and effective method of using the trust property. Institutional structural change and societal change are just two broad categories that came to mind. Some examples are gleaned from the work that we're conducting at the University of Sydney to ensure that we're maximising the use of our charitable gifts and discharging our fiduciary obligations as trustee, are set out on the slides. The first category I've looked at are what we might call gifts that are subject to institutional change. The University of Sydney holds a surprising number of perpetual gifts which carry conditions that seem to have assumed that the structure of the university and the course and programs it offers will never change. We have, for example, gifts that reference scholarships or prizes for students in undergraduate courses, but now many of our courses are offered only at graduate level. We have a gift for a scholarship in opera for students who are in the second year of their specifically undergraduate degree. We have prizes in the Bachelor of Medicine degree. Medicine ceased to be a bachelor's degree some years ago, and it's now only available at graduate level. We have gifts for prizes in subjects that are no longer taught as a discrete unit of study, and so require an extraordinary level of effort for the faculty staff to discern the student who is placed first in course. There are also a surprising number of perpetual gifts which specify an award value without making provision for the award value to increase in line with inflation or the income of the capital. We have, just as one example, a gift given to us in 1939 of £100 to award a scholarship of £4, with no internal mechanism to ensure that the value of the award remains meaningful. Still on the subject, I guess not so much of institutional change, we have other gifts that suffer from an accumulation of funds because the trust terms don't allow sufficient flexibility to award, for example, more than one scholarship, where a gift term specifies, as is very frequently the case, a scholarship. I think the Royal Botanic Gardens Trust dealt with that issue. And as Natalie has said, while there's certainly avenues available to have these kinds of terms varied, the process can be very onerous and time consuming, and indeed is not always successful. We've had an enormously difficult period trying to get through a variation to a prize that specified the gift had to be awarded to award an anatomy prize, anatomy being a subject that's taught as part of now a 2-year block course of study that's examined as a barrier exam. It's almost impossible. So there is no subject called anatomy as such anymore, certainly within the medical degree. And I have to confess that the process that we were put through by the Crown Solicitor's Office to interrogate us on every element of the management of that prize, since it was provided 50 years ago, ended up exhausting us, and we gave up and came up with a different way of managing the difficult gift. The other class of restrictive terms which causes difficulty are those which seek to limit charitable benefits on the basis of sex, race or religion. We have many gifts at the university of this kind. We have gifts to provide scholarships to study engineering for male students only. We have gifts to support the sons of Protestant ministers. We have gifts to support students of British parentage. Not only are these gifts obviously very difficult, in some cases simply to award, even if we were of a mind to do so, they create some very significant difficulties in terms of the institutional appetite to proceed. We're certainly cognizant that conferring charitable benefits is exempted from the forms of conduct potentially unlawful under the applicable anti-discrimination legislation, although we do spend an awful lot of time writing letters to people explaining that that is the case. But in any event, publicly advertising and awarding scholarships intended to benefit only men or students of British parents is now so out of step with contemporary societal norms and university values as to be unworkable. And yet, from a practical perspective, really only Section 9 of the Charitable Trusts Act is available, as the university's own internal CPRE provision, which Natalie outlined earlier, sets the bar at impossible or inexpedient. And the reality is, in many cases, we can't meet that bar. A real example was an application that was made under Section 25 to vary the terms of an engineering scholarship, which specified males only. And we sought to remove the gender restriction. This was rejected on the basis that, and I quote from the Attorney General, there were sufficient numbers of eligible male applicants successfully applying for the scholarship, and therefore an argument for inexpediency could not be made. So certainly we understand that there it's also not the general principle in Australian law that a charitable trust for the benefit of one gender to the exclusion of all others will not justify a CPRE scheme by reason of it being void as contrary to public policy also doesn't assist us in our efforts. It is heartening that there are some recent cases that have viewed discriminatory terms through the suitable and effective method of using the trust property lens, and that case is certainly providing us with some hope. Interestingly, we also find that as a progression of these sorts of issues, we're in fact under pressure to interpret what might be regarded as positively discriminating charitable trusts, for example, prizes for females, in a more gender fluid way. And these kinds of issues are creating further challenges for us, particularly from the perspective of trying to honour donor wishes against the needs of the charity to effectively use our gift funds in a way which accords with our charitable mission and meets expectations of the present community.
I'm sorry to jump in here, Katrina. We've got, I think, 4 minutes left.
Okay.
Well, and I'm just tracking questions and things, but thank you.
Okay. Well, really just the last slide was saying, what are the solutions? One solution, certainly for our historical gifts, is to wonder whether there's a role for the ACMC in this to create perhaps a more streamlined variation or enable a more streamlined variation process. From our perspective, for new gifts, the alternative is to not create a charitable trust. That's difficult and not necessarily favoured by donors, but by using the mechanism of the preference rather than a binding obligation. But as I said, it's really a question of balancing the honouring donors' intent and providing sufficient flexibility to allow charities to continue to operate. Thank you.
That's great, Katrina. Thank you so much for that. It's paradoxical given that the University of Sydney Act, which dates back to what, 1855, I think by memory, has some quite unusual and forward-looking prohibitions against discrimination. And particularly the role of women in education. Anyway, that's an interesting byline. Have a read of it sometime if you're interested in the history stuff. I've been watching to see if we've got any questions of this this wonderful panel. We only have a couple of minutes left.
Yes.
Picked up Matthew's comment about those trusts being found contrary to general public policy. You want to elaborate on that maybe, Katrina?
Oh, no, look, just Matthew's right. The law in Canada is different. Unfortunately, we're not there yet in Australia. And I think we're hopeful that we can rely on, as I said, an argument that the discriminatory terms are no longer a suitable and effective method of using the trust property to forward our arguments. There's the case that in that particular case, though, the charity wasn't the trustee of the funds. The charity was the recipient, was the purpose. It's a perhaps a little bit more difficult in the case where the charity is the trustee itself, so we can't give the money back to ourselves, so to speak, and thereby make it impossible for the trustee to administer the gift.
Thank you. It seems like you're supporting the argument that some of us have been running for some years now, that the Attorney General should delegate his or her role as Chief Law Officer, as Protector of Charities, to the Charities Commission. That would be a solution that you've got, that you were referring to a moment ago, that would provide an administrative solution to the inflexibility of some of these trusts. But that's probably a topic for another day. I wonder, Mary, if you've got any final comments, if you're still there and you haven't heard news of your new grandchild who's imminently to be born. But anyway, it's lovely to see you still there, Mary. Do you want to make a final comment?
No, just to thank you so much. I should have said at the beginning, but I was so intent on getting through my time and getting as much in as I could. Thank you very much for including me today. It's been a wonderful opportunity for me, and really interesting. I was in the first session and of course in this one, but I'm sorry I did try to catch some kip in between. And just to reiterate, please, if anyone does have any questions or comments at all arising in respect of universities through the charity law lens, that Mary Synge charitylaw@outlook.com email, please do get in touch. You won't catch me at Exeter after mid-September. But no, there are just so many broad questions. I think it would be wrong for me to try and alight on one, but thank you for the comments in the chat box. I have noted those.
No, thank you for that, Mary. And we're looking forward to the book with great interest, and keep writing, please. It's a great gift to us all. Natalie, did you want any final? We're about to have our mics turned off, I think. One final comment from you, Natalie.
Well, no, I just wanted to say thanks again, like Mary, for the conference as well. It's been a great day. Thanks, everybody.
Thank you. Well, back to you. Are you still there? Matthew, there you are, Matthew Harding. No, Ian. Ian is finally going to bring us to an end at the end. Thank you, Ian.